This is a long question, so I'm going to read it out and then we'll take it sort of bit by bit. So part of the GDPR is enhanced right to access. Does this mean that the user is entitled to get a complete copy of all the data relating to them regardless of who paid for this? And what exactly is included in inverted commas, further, the controller shall provide a copy of the personal data free of charge in an electronic format, close the inverted commas. And then, are there any restrictions on the citizens on what they can and cannot do with the data once they've received it? So first of all, I suppose just to specify, right to access is a right for the personal data, for the data subject to seek and be given all of the personal data that an organisation holds in relation to that person. So remembering that, personal data is any pieces of data that on their own or together with other information that held by an organisation can identify that data subject, okay? And this is a personal right of the data subject. So around the first question about whether or not it extends to personal data that has been paid for, the creation, I presume, is what the question is intending to ask, has been paid for by somebody else or by the organisation. If you go back to brass tactics and the fact that this is a personal right and a data subject themselves owns all the personal data relating to them, I think that answers that question in the sense that it's all personal data that an organisation holds on behalf of a data subject. Then what is exactly included in the personal data being produced in electronic format? So obviously people can make a request for their personal data in electronic means, so either by email or alternatively through a company's website. So where the information is requested in that manner, well then it must be provided in an electronic format also. So that's really a situation where the personal data, the data subject themselves, or alternatively another organisation, can be able to read the personal data again on laptops or other means electronically. So that's in relation to that. Also, that question also deals with the fact that now access requests they need to be complied with free of charge. So under the current regime, an organisation can charge $6.35, and that again is for the most part. There are some very limited exclusions where an organisation can charge for complying with an access request. So just to note that. So then the final part of the question was, are there any restrictions on the citizens and what they can do with the data once they've received it? Again, going back to the answer around the first part of the question, it is the personal data belongs to the data subject. So thinking around that, I suppose flying from that is the fact that as they own the personal data, well then in those circumstances they can do with it as they wish. However, I would just note that under Article 15.4 that a right to obtain a copy of your personal data that's being processed by an organisation cannot adversely affect the rights and fundamental rights and freedoms of another person. So just, I suppose, to put that in by way of condition there. So again, just a couple of things around data access requests. I've already mentioned the fact that under the new regime there'll be no charging. Also, there's additional information that you have to give around letting the data subjects know that if there's any personal data that you give them that is inaccurate on foot of a data access request, that they can request for that to be corrected. And also you need to let your data subjects know around restrictions around your retention policy. So it's really important, obviously, for organisations to ensure that they update their policies and procedures as they will be under the GDPR, and also to ensure that all staff are trained in relation to them.